Hello friends, welcome to the second part of the Singapore Convention on Mediation 2018. So in this part we will be discussing about the provisions, the articles of the Singapore Convention in a bit of a detail, and we'll also be taking up a case study to understand the scenario which existed before the existence of the Singapore Convention and after the Singapore Convention. This would help in simplifying your understanding about the convention and how has it benefited us. So to start with, we have the documents that are required for the enforcement. So this has been provided by Article 4 of the convention. So it provides for the production of the evidence of the settlement agreement which resulted in mediation as a proof to the competent authority, which shall check the authenticity of the evidence. So Article 4 provides that the proof of the mediation settlement which shall be furnished to the competent authority who will check the authenticity of these evidences. So an evidences have to be produced before the competent authority to show the existence of the settlement agreement. Next is to eliminate any illegitimate practice. While verifying the authenticity of the documents produced as evidence, the competent authority may call upon the parties to provide for further documents necessary to substantiate the authenticity of the documents provided. So in order to eliminate any of the illegitimate practice, that is there is no foul practice which has been undertaken, so the competent authority has the power to call upon the parties to furnish further documents in order to provide the authenticity to the documents which they have already furnished. What can be given as evidence? So now we'll be seeing that what can be furnished as an evidence to the competent authority. So first among them is the signature of the mediator on the settlement agreement. Next is signature of the mediator on a separate document expressing or indicating that the mediation has taken place. So it can be on the document, on the settlement agreement, or it can be on any other document which expresses or indicates that a mediation settlement was in place. Third is attestation by the administering institution. So there can be an attestation by the administering institution which can be furnished as an evidence for the settlement agreement. Next is any other valid proof as acceptable by the competent authority. So any other valid proof that the competent authority requires, that can also be furnished. Next is what are the grounds for refusing the enforcement? Refusing enforcement of what? Refusing the enforcement of the mediated settlement. So on what grounds can the enforcement be refused? First is incapacity. If a party to the settlement agreement is incapable of making this agreement, the execution of the agreement may be refused. So if the party to the settlement agreement, that is the state, the contracting party is incapable of making of entering into a mediation settlement, then that enforcement of the mediation settlement can be refused. Second is invalidity of the settlement agreements. So if a settlement agreement is void, ineffective, or impossible to implement, the enforcement request can be rejected. This provision is the same as the invalidity terms of the arbitration agreements in Article 2, Clause 3 of the New York Convention. So in the second point, we are seeing that if the mediation settlement is either void or ineffective, or it is impossible to implement, then the enforcement of the mediation settlement may be refused. So this ground is similar to the ground given in the New York Convention under Article 2, Clause 3. Third is a settlement agreement is not binding or final, nor may it be subsequently changed. If a settlement agreement is not binding nor final according to the terms of the agreement, enforcement request may be refused. This provision will only be enforceable if the party expressly states that the agreement is not binding or final. So if the party to the mediation settlement states that the mediation settlement is the agreement is not binding and final, in that case only this point can be taken up upon. So in this, if the mediation settlement is itself not the settlement agreement is itself not a binding settlement or a final settlement, then it may not be enforced. Also, it cannot be subsequently changed. So whatever has been there in the settlement agreement, that cannot be changed subsequently. Next is the execution of settlement agreements. If the undertaking specified in the settlement agreement has already been fulfilled, the enforcement of the settlement agreement cannot be demanded. In case of partial performance, the enforcement request can be made only for the unperformed part. So in this point, we are looking at the angle where the undertaking, whatever has been specified in the undertaking, that has already been performed. So there's an undertaking in the mediation settlement agreement. So if that undertaking has already been fulfilled, in that case, the enforcement of the settlement may be cannot be demanded. Also, in case there is a part performance of the settlement agreement, in that case the enforcement can be demanded only for the part that has not been performed yet. So this point is very simple, as it is that if the undertaking is itself already fulfilled, then the enforcement cannot be demanded. Next is if a settlement agreement is unclear or incomprehensible. The fact that a settlement agreement is not clear or intelligible was regulated as a reason for the denial of execution. So if the if the mediation settlement agreement is itself not clear or intelligible, that is, it cannot be comprehended clearly, then in that case there can be a denial to the enforcement of the mediation settlement agreement. Next is if the execution is contrary to the provisions of the settlement agreement. If the enforcement request is contrary to the terms of the settlement agreement, the request may be refused. Accordingly, if the parties have accepted a jurisdiction clause for the execution of the settlement agreement, requests contrary to that clause will not be accepted. So this point is pretty much simple. In this point, they are saying that if the enforcement request is to carry out a certain thing, for example, the enforcement requires some A to be done and you are requesting for B to be done, then that request will not be acceptable. Obviously, if the settlement says for A, then you have to ask for A only. So anything contrary which is asked against the terms of what has been there in the settlement agreement, that will not be welcomed. Also, if the parties they agree to a particular jurisdiction clause that they would abide by that particular jurisdiction, concerned jurisdiction, in that case deviating from that jurisdiction clause will also not be accepted. Next is if the subject of the dispute is not suitable for mediation. If the subject of the dispute is not suitable for resolution through mediation in accordance with the law of the state party, the execution settlement may be refused. So, as per the law of the state, if the dispute, that particular dispute, is not fit for mediation, then the execution of such mediation settlement may be refused. Next is mediators' abuse of power. The Singapore Convention has also accepted the rejection of the execution of the settlement agreement due to reasons arising from the mediator. Accordingly, if the mediator has seriously violated the standards applied to the mediator and the mediation, and if the relevant party would not have made the settlement agreement without this violation, then the enforcement of the agreement may be refused. So this ground stems up from the mediator itself. So if the mediator is not following the particular norms, the standards that a mediator has to comply to, in that case also the enforcement of the mediation settlement can be refused. And one important factor here is that if the relevant party would not have made the mediation agreement without this violation. So this factor also has to be taken into consideration, that the mediator has seriously violated the standards or the norms to which he is duty bound to comply to. If the execution of the settlement agreement is contrary to the public order. The execution of a settlement agreement which is contrary to public order of a state party is a ground for refusal. It is accepted that the approach regarding the exceptional and narrow interpretation of the concept of public order in the New York Convention is also valid in the execution of settlement agreement. So in this point, what we are looking at is that if the mediation settlement agreement, it goes against the public order of that state, in that case, the enforcement of such mediation settlement agreement can be refused. So when we talk about public order of the state, the same meaning will be carried as if the meaning is given in the New York Convention. So the mediation settlement agreement shouldn't be against the public order of that particular state party. Next is the reservations to the convention. So the convention mentions 2 reservations. So we'll be looking out on that. The Singapore Convention allows the contracting parties, that is the states, to make 2 reservations. First is, a contracting party may declare that it will not apply the Singapore Convention to the IMSA to which it is a party, or to which any governmental agency or any person acting on behalf of the governmental agency is a party, to the extent specified in the declaration. So a declaration can be made of not applying to the Singapore Convention. So even if there is a settlement agreement, so a party can if there is a declaration by the party, the state party, stating that it will not comply to the Singapore Convention, then also if there is a involvement of a government agency or any person acting on behalf of the governmental agency, then that will not apply to the extent of such declaration. Next is, a contracting party may declare that it shall apply to the Singapore Convention only to the extent that the parties to the IMSA have agreed to the application of the convention. No other reservation is permitted under the Singapore Convention. The second is that if the party shows a limited application of the Singapore Convention. So if the party declares that there will be a certain extent of the application of Singapore Convention, then only the convention would be applicable up to that mark. Before you have a pictorial representation of what we just discussed. Now, what are the major concerns when we talk about the Singapore Convention? What are the major things on which we need to ponder upon when we talk about the Singapore Convention? What lacuna does it have? What things does it fall back on? So one is that there is no straitjacket formula or standards listed for the qualification of the mediator. Regulation of such practice cannot be left to domestic laws, as this would create disharmony among the municipal and international laws. So when we talk about the mediator, There shouldn't be any abuse of power by the mediator, as we have already talked about, that if there is an abuse of power by the mediator, then it becomes a ground for the refusal of the enforcement of mediated settlement. So, what should be the qualifications for a mediator? That has not been provided by the convention. And if we leave this matter for consideration upon the domestic laws, then it will again lead to a disparity between the municipal and the international laws. Next is the convention stresses upon the confidentiality involved in acting through mediation, but the cumbersome formalities and compliances provided under Article 1 does not seem to be in favor of the same. So, when we talk about mediation, as we have discussed in the previous lessons, we know that mediation is a very confidential affair. So, when the mediation has to be a very confidential affair, the convention has to have a very supportive provision as to how this confidentiality should be enforced. But when we see the cumbersome, that is the technical formalities and compliances which are required as per Article 1 of the convention, this makes it a very tedious task. Next is the provision to opt out of convention by expressly providing in terms of the settlement agreement tends to limit the applicability and the purpose of the convention of submitting to the provisions of the convention and facilitating cross-border international dispute settlement. So, as we've talked about earlier, one of the major goals of the Singapore Convention is to facilitate international trade and to have an easy enforcement of the mediation settlements in cross-border disputes. So, in this regard, as we talked about here, that there are certain reservations. So, if there's a reservation which extends that state party, it can limit the applicability of the convention. In that case, the entire purpose of the convention would be defeated, which is to resolve the disputes through mediation and the promotion of mediation, that is, and secondly, to get an easy and streamlined procedure for the implementation or the enforcement of the mediation settlement. So, if the parties can themselves limit the applicability, then the purpose gets defeated there. Next is that the convention is silent on the form of the enforcement of MSA. MSA means Mediated Settlement Agreement. It does not mention whether the enforcement of the MSAs would be done by providing relief in the form of damages, specific performance, or any other remedy as required and sought for as applicable as per the legislations of the nation where the enforcement is applied for. This acts as a concern because the laws of the domestic countries differ in their provisions with regard to the provision of relief, and hence the uniformity to be achieved via the convention will fall apart. So when there is a dispute, there is a different way or there's a different provision altogether in different countries to handle that dispute. So the Singapore Convention does not maintain any uniformity as to how the MSA would be enforced, whether it would be enforced with the help of providing damages, or it would be by providing for specific performance or any other remedy. So if we rely on the approach of different countries, that would be different. The way a particular country addresses that concern would be different. So in that case, there would be a very there'll be different approaches by different countries, and therefore it will not be uniform. So the convention lacks here when it comes to uniformity with regard to provisions of relief. Now, no matter how much we talk about the concerns and the fallbacks of the Singapore Convention, but when we have gone through all these topics relating to the Singapore Convention, the long and short of the story will arrive at that the Singapore Convention has been a very important step towards step forward towards the implementation of the international framework for using mediation as dispute settlement. Not only has it promoted mediation, but it has also helped and facilitated international trade. As we've discussed earlier, since there is more trust upon the countries who are signatories to the Singapore Convention, it becomes easier for the trade to be there, and thereby the enforcement of any mediated settlement agreement. So the risk involved becomes less, and the procedure becomes simplified and streamlined for the enforcement of mediated settlements. Now we'll be talking about a case study. As I said, that we'll be taking up a case study and we'll be seeing how the scenario was different before and after the convention. So here there's a contract of sale of goods. So the seller and the buyer signed a contract for sale of goods. The seller, he fails to deliver the goods as per the contract, and therefore the buyer did not pay the price for the contract. The buyer and the seller decided to go to mediation. The mediation process was successful and the buyer and the seller signed a settlement agreement. According to the settlement agreement, the seller had to replace the goods with a different product within a period of 1 week of signing the settlement agreement, and the buyer had to pay the price within 2 days of the delivery of the new product. Now, the seller delivered the new product as per the settlement agreement. However, the buyer refuses to accept the delivery of the new product and tries to enforce the original contract. What can the seller do in such a case? So I'll summarize this. So basically there's a contract of sale, and in which the seller has failed to deliver the goods as per the contract. So what the contract demanded, as per that the seller failed to deliver the goods, and the buyer henceforth did not pay the price of the contract. Now when the buyer and the seller go for mediation, they arrive at a mediation settlement under which the seller promises to replace the goods with a different product within a period of 7 days, and the buyer would have to make the payment within 2 days of the delivery of the new product. But now when the seller is delivering the different product, the buyer, he refuses to take the delivery of the new product and he wants the enforcement of the original contract. So in this case, what can the seller do? So first we'll be seeing a scenario which would have happened before the coming up of the Singapore Convention. So before situation is that the seller had to enforce the settlement agreement like a contract or according to the domestic laws of the jurisdiction where enforcement is sought. So what the seller would have to do before the coming up of the Singapore Convention is that he would have to take the traditional route of going to a litigation process following the laws of the country where he wants to get the enforcement done, and a lengthy court process would be the chosen path for the seller. But now when we talk about a scenario after the existence of the Singapore Convention on Mediation, in this case the seller can invoke the settlement agreement and prove that the matter had been resolved by a settlement agreement, where the buyer seeks to enforce the settlement agreement in a jurisdiction that is a contracting party to the Singapore Convention. The settlement agreement is a complete defense. The seller also can enforce the settlement agreement directly, similar to how awards and judgments are enforced in any contracting party under its rules of procedure in accordance with the conditions set out in the Singapore Convention. So long story short, we can say that the seller after the Singapore Convention can produce that settlement agreement alongside all the evidences that we discussed, the documents that have to be furnished, he can just show the settlement agreement and say that this matter was already referred to mediation and it has been settled in this way. Now the buyer, if he wants, he can use the settlement agreement in his defense, and the seller, since the buyer country is a signatory to the Singapore Convention, he can get his mediated settlement directly enforced in the country of the buyer and in a very simplified procedure without following the lengthy court procedure, in accordance with the conditions that are set out in the Singapore Convention. That is, all the documents have to be shown, and the grounds that we discussed, all those, after stating that, he can easily get his settlement agreement enforced. So I hope you enjoyed the class. This was all for today. Thank you so much. Thank you.